Friends, today's NRI Samay program from Los Angeles brought to you commercial-free by listeners like you. Your generous donations make possible for us to stay commercial-free, and today's show is pre-recorded. If you have a question for the guest, please send an email to nrisamay@gmail.com. We will follow up with the guest and find the answer for you. Thank you for your support.
So friends, welcome back to NRI Samay. I'm your today's host, Srikanth. Now, President Barack Obama unveiled U.S. immigration reform, one of his biggest use of executive actions, bypassing the Congress. There are too many things he talked about in one piece, but for Indian community, it's a matter of curiosity and also anxiety. So joining me now from Los Angeles is Ramesh Kotamurthy, works as a senior project manager in a Fortune 500 company, has been a leading voice in advocacy and grassroots campaign for immigration reform for high-skilled immigrants for several years. Also led campaigns and events for reduction of green card backlogs. Very familiar with intricacies, nitty-gritties of the American lawmaking process. I've been closely involved in comprehensive immigration reform legislation as well. Ramesh Garu, thank you so much for joining the call, sir. I appreciate your time.
Thank you. Thanks for having me.
Thank you, sir. Thank you. So there's a lot of confusion, curiosity, and also anxiety, sir, as far as Obama's announcement today is concerned. So let me jump right in. In a generic sense, Ramesh Garu, whatever President Obama talked about today, is there any clarity on timelines on when these processes will be in effect, sir? Did Obama really talk about any time frame?
Obama did not give time frame, but Department of Homeland Security, which is the implementing agency for all these reforms, they have given some timeline. You can actually refer DHS website. They have given a timeline of about 6 to 7 months for most of the provisions.
Oh, what is the website, sir? Can you give us the full website?
DHS.gov.
DHS.gov.
Yeah, Department of Homeland Security, DHS.gov.
All right, perfect. So let's come to this quotas. That's also a matter of interest for a lot of Indian immigrants as well. Is there any increase in quota or even merging the quotas for different countries? Because right now it's an unfair quota system that we see, right? What do you think about this, sir?
No, this executive order does not cover anything about quotas or merging of quotas. Quota system is something which is written in law, and it requires a legislative change which has to be passed by the Congress. So the executive order cannot make any changes to increasing the quota or even for that matter recapturing visa numbers. Some people expected that there would be a recapture of visa numbers, but that requires a legislative change which only Congress can pass. And this being an executive order, it does not have anything to do with the quotas or increasing the quota or recapturing visa numbers or anything like that.
So the 65,000, 20,000 and all of these would remain same as is, right?
You mean 65,000 is H-1B visa quotas.
Right.
That has not changed, no. H-1B is a different category, and then what we're talking about is green cards. And the green card quotas, there is a cap for every country. There's a 7% cap for every country. None of that has been changed. That still remains because that requires legislative change.
Okay. So let's talk about H-1Bs. Mm-hmm. At what point can H-1B holders safely switch between employers without fearing of losing the GC status? What do you think, sir?
Assuming that employer has filed for green card and the green card process has gone through labor clearance, and
which is a perm, right?
Has gone through, which is perm. It is now called perm. Earlier there used to be a regular labor clearance process. So whatever it is, that means Department of Labor has cleared that there is whatever clearance they have to give from their side, that is done. And then I-140 is filed. I-140 is actually employer confirming that there is a job for this person in their company. So once that is done, then that person will be able to do a pre-filing. That's what they're calling it. And based on that pre-filing, they should be able to apply for EAD cards, which is Employment Authorization Document. Not just the primary applicant, but even the dependent. They should be able to apply for EAD cards.
Okay, perfect. So how about L1 visa? What changes can we expect for the L1 visa?
The only write-up I have seen for L1 visa is that it is going to be implemented similar to H1 visa, which means the market testability is going to be included. So that means right now when you file for a H1B visa, there's a labor condition certification also done. It means that it is posted in your employment place and all. There are certain rules that need to be followed for H1B visa. Whereas for L1, there is no such condition. It's just an intra-company transfer. There was no market test for L1. But that is, proposed to be introduced. That's what is the, guidance that I'm seeing.
Okay. So now the dependent visas, H4, right? We have Rajesh from Pleasanton, California. He was asking a question. I have approved I-140. So can my wife work who's on H4? Can she really start working?
Yeah. In fact, H4 can start working with, irrespective of your green card application or not. H4 should be able to apply for employment authorization document. That is provision 1. And provision 2 is, yes, with the I-140 being approved, primary and beneficiaries, all of them can get, EAD cards. But there is a registration part. I think what DHS is going to do is actually publish what are the timelines when they will start accepting applications. We should watch out for that. It might take probably around 6 months for them to actually come out with a complete regulation and website on where you can file for EAD cards and things like that. But to answer the question, in short, yes, she should be able to apply for EAD card, and then once they get it, they can start working.
Okay. So, and also, as you mentioned earlier, if you go by the DHS.gov website, we're looking at 6 to 7 months time frame from now, expected. Right. Of course, we don't want to really bank on specific dates or something like that, but tentatively, in the next 6 to 7 months, we should see some sort of progress, right?
Right. We should see some sort of progress, and DHS has not announced what is the fee structure for these things, so there might be a change in fee structure because the way DHS works, this is not coming from appropriated budget. So DHS works based on the fee that they receive from the applicants. So if they receive, let's say for example, we are expecting that about close to 800,000 people will be applying and they'll be affected by this. So they'll be applying for EAD. We are talking about only the legal immigration part. We're not talking about the undocumented. So just the legal immigration, the high-skilled immigrants, the employment-based immigration, they're expecting relief for roughly about 800,000 people. So imagine the rush that will come in, and of course DHS has to ramp up their people, ramp up all the resources in order to process these applications. So in order to ramp up, they will hire new staff. They'll also augment their facility, but they expect all those things to be funded through the fee. So that means there is going to be a separate kind of fee. That's what is my reading into this. And they've not announced what the fee is going to be, so all those things need to be worked out. So yes, it is going to definitely take time. Probably, that's the reason the expectation that DHS is setting up is that it should take around 5 to 6 months to have a clarity and have an office where these applications can be processed.
Okay. So now talking about the PERM process, which earlier was called labor approval or something like that, right? Mm-hmm. So now Srinivas from Fremont, he's asking a question. What is this new PERM modernization? What does it include, sir? What is this new terminology?
I have no idea, no clue what he's talking about. No, I have no idea about the perm modernization process.
All right. So any changes as far as perm is concerned, or it's all the same thing right
now? Not that I know of. Whatever is the existing process, it's going to remain the same.
All right. Yeah. Perfect. So now let's come to I-140, right? So Akhil from Fremont again, she's asking a question. I have an approved I-140 in my old company, but I did not port it in the new company. With the new immigration policy, can I avoid now the painful porting process or not?
Again, this really depends on what DHS interprets this executive action as. Will it be retroactive from whatever time? We don't know those mechanics yet. It really depends on what are the if DHS gives certain sunset dates or not. Excuse me. So I think we have to wait for clarification from Department of Homeland Security on this.
So there is a speculation that at the moment, the guys who are on I-140 are people who are on I-140. So as you know, the existing situation is that if a person is on an I-140 and he loses his job, he'll have to move to a new employer and again start the perm process on I-140. With the new immigration reform that Obama has announced, there's a speculation that this is going to go off. So is that true, sir?
It's not speculation, it is true. Now, what used to be I-485 as a breaking of shackles, if you may call so, now I-140 is the breaking of shackles. So when you have in the earlier situation, people used to file for I-485 or adjustment of status when the visa numbers were available. That means your date has become current, and every month you would go and see the visa bulletin, expecting that your date has moved by 1 day or 2 days or 1 week or something. Now all those things will be things of past. So what is going to happen is, as soon as I-140 is approved, you will the beneficiaries will be able to file for EAD cards, and once you have the EAD card, you are free to port from any job. And then there's also one of the provisions that Immigration Voice was is to declare what is the qualification for same or similar job. There is still a very narrow interpretation of what would be considered as a same or similar job. So now that narrow qualification is going to be taken out, it is going to be reworded. That means once you are on, let's say, the employment authorization document, if you want to completely change your profession, you should be able to do it. Let's say you're from, I'm talking typically about technical folks because we're talking about H-1Bs here. So let's say you're a senior developer or a lead, and you want to move into management. Let's say, for example, you become a development manager, or you want to move into a project manager position, or into an architect position. In the earlier world, it was not considered to be a same or similar job, so you had to go back and stand in the back of line and reapply for the entire immigration process. Now that is going to be redefined, and that same or similar clause might be either modified in such a way that it is broadened to an extent where you should be able to continue in the same technology job. In the earlier world, it was limited by Department of Labor's qualification. They had some numbers. So unless you fall into those numbers, you wouldn't really be able to port your green card application. So with this new executive order, that is going to be revised, and people should be able to port into different jobs.
Okay. So like me, if I'm right now working in a technical job in a company, if I want to pick some sort of journalism job, would I be allowed to do so, sir?
Hopefully, yes.
Okay.
Yes. I don't know how liberally they're going to define it.
Okay.
But absolutely, All you might have to switch to is another job which would require an advanced degree.
Okay.
So something on those lines. I don't know the exact interpretation and how well Department of Labor and Homeland Security will be able to come up with it. But they have put up a working group on this. DHS has announced that they are having a working group specifically to address these kind of quirky questions. And they have said that they're going to include attorneys. They're going to include all the interested stakeholders, including people like our advocacy groups. They're going to include all of them in making those decisions on how to interpret and how best to help the high-skilled community.
Got it. So now there is another question that's coming through, and the question is, would these I-140 folks will be issued any sort of cards like EAD card or anything of that nature, or it's just a matter of interpretation, like I-140 will be similarly interpreted as I-485?
No, you have to apply for the EAD cards.
Okay.
It's not automatic. You'll have to apply for EAD card, and like I said, there might be a separate fee for it. It may not. The EAD card fees is very likely to be changed. And when I say changed, it is probably going to be increased. Never. Right.
And that warrants. Yeah. And that warrants a question asking. So all these guys who are on I-140 should be ready with their documents and all of their necessary and needed infrastructure in order for them to apply for this EAD cards, right, sir?
Right. Yeah, but EAD card doesn't require a lot of paperwork. It's probably pretty simple.
Yeah, birth certificates and all of this, I think that would become
birth certificates and all is for adjustment of status.
Okay.
Whereas EAD would not require all that. All EAD would require is probably just the I-140 approval and some photographs and things like that, but nothing beyond that.
Got it. Sir, in a simple layman terms, including me as a lame duck trying to understand, what would be the benefit of a guy having an I-140 now moving to an EAD status, sir, with this new immigration policy? Just as a summary.
Portability. You can go to any employer that you wish. It's no more, indebted servitude. Earlier it is like it's a kind of slavery. If you are filed for green card, you have to stick with your employer until the green card process is completed, which could be a decade. In many cases it has gone over a decade. So now I-140 is a gateway for people to move around. That means if you don't like your employer, you can quit your job, go and do something else.
Got it.
So what used to be I-485 gateway is now that goalpost has shifted and it has come more closer to I-140. So what it means is there might be more clamor for filing I-140, and even employers are very smart. They might adapt and they might stop applying for green cards altogether. That's another way of holding on to people.
Yeah.
So is it going to give relief to people? Absolutely. Is it going to change the way things are working right now? Absolutely. Will it bring any relief to on a longer term? The jury is still out there. We don't know yet.
Awesome. Wonderful way of explaining it. So the second question here that I've got is that with approved I-140, is there any minimum limit of number of years we will have to wait until we apply for EAD? No. Like my I-140 got approved a few months ago. Am I good to apply for the new EAD that you're mentioning about?
There should not be any waiting period at all. I'm not sure if you can apply 140 and EAD together or not, if that would be the interpretation or not, but definitely there is no waiting period. As soon as the 140 is approved, you should be able to apply for EAD.
All right, perfect. And Srihari Atluri from Los Angeles, sir, his question is there any sort of speeding up in issuing green cards and any movement in the dates?
There may not be any speed up of issuing green cards. but the dates might be irrelevant. The reason I'm saying dates might be irrelevant is you can file for the adjustment of status I-485 at any point of time if the I-140 is approved. So there is a temporary relief in terms of EAD, but what might happen is that people will be remaining on EAD for decades maybe. EAD was supposed to be a temporary thing, 6 months to 1 year, after which you would get the green card. But with these changes, all that is happening is people are going away from H-1 visa, probably shifting on to EAD and probably remaining on that for I don't know how many days, depending on the category. Is this going to change? Are you going to get green card sooner with these provisions? Probably not. Because that is all dependent on the numbers, and that is dependent on the quotas, like I was saying earlier, and those quotas can be changed only through legislation, only by the Congress. It cannot be changed by executive authority. So if we have to see whether, have we achieved anything? Yes, we did in terms of temporary relief, but is this the goal post? Have we reached the goal? Not yet. There is still a lot of work that needs to be done, and congressional laws have to change in order for people getting out of this mess altogether. Has getting green card become easier, or has it become easier to stand in line? So right now it is you're still going to stand in that line. Only thing is, when you stand in that line, you might have a little more comfort in standing in the line. You're not getting there any faster.
Got it. And sir, one final question from Anand Sharma from Longmont, Colorado. I think that nullifies all that you have told about. So he was asking, I have an EAD advanced parole for the last 6 years. Will my priority date get current with the new rules? I think it's absolute no with whatever you've mentioned right now.
Yeah, but the priority date concept is lost, because the way the bulletins are being done, the whole logic behind DHS official who does the bulletin, Department of State, which does the bulletin, visa bulletin, I think that whole concept is going to change. In fact, even in President Obama's speech and also in the write-up, if you see, there's a clear mention that the way the bulletins are being prepared and the way visa dates are being projected, that is going to change. So what exactly is the change, how it is going to change, I'm not sure at this point of time how all those things are going to change. But for those who are uninitiated, who are not very deeply involved in this process, it might be interesting for you to know that the Department of State, the State Department is the one which creates visa bulletin, and DHS is the one which actually implements, takes visa bulletin and actually issues visas to people. So all those things are being streamlined. At least there is an intention with the executive order that all these things need to be streamlined. And, I remember very frequently, every month you wait for 14th or 15th of the month to look at the visa bulletin. Hopefully those days are gone, and you don't have to plan your entire life around visa bulletins and dates and EAD approvals and things like that. Hopefully we'll get away from there. But how soon? We'll have to wait and see. Maybe it's a matter of a few months before we get away from that.
Got it. So one last question. I should have asked it when I asked about H4 itself, is that when we talk about H4s getting EADs, is there any time limit that the spouse or anyone who's working here for at least 5 years and his wife would be allowed to work, would be allowed to be given an EAD, or is there any time limits, or anybody who's in the U.S. right now would be eligible for this?
Anybody who is H4 need not be just spouse. Okay, H4 could be even dependents who are, let's say, aged out dependents. For example, anybody over 21. Even they can actually get, employment authorization documents. So anybody who is currently in a legal status as a dependent should be able to get EADs.
Awesome. So Ramesh Garu, thank you so much for your time, sir. I think with all the questions that I've got right now, you've answered each and every bit. Absolutely, great effort. And also from Immigration Voice, also phenomenal work from your side. And from all the community folks here, we should congratulate and thank for all the efforts that you've been doing. And I request all the listeners to go to immigrationvoice.org and then take a look at the work that they do. Phenomenal work. And you've also shared some documents which we'll be posting online as well. So, and also I request all the listeners who are listening to this show to write to us at nrisamay@gmail.com. If you have further questions, we'll route it to Ramesh Kotamurthy Garu. And thank you once again, Ramesh Garu, for your time, sir.
Thank you. Thank you so much.
Thank you. So, friends, that was Ramesh Kotamurthy Garu. And Ramesh has been working on the immigration side of the activity for quite some time. And I know there's a lot of anxiety and also curiosity about what was unveiled today by President Barack Obama. And I think enough information has been given by Ramesh Garu. So once again, has been a leading voice in advocacy and grassroots campaign for immigration reform for highly skilled immigrants for several years. And I think you get all the needed information once you listen to this. Please do come back to NRI Samay. You can write to us at nrisamay@gmail.com, facebook.com/NRI Samay, twitter.com/NRI Samay. You can listen to all our archives at youtube.com/NRI Samay. Once again, thank you so much and have a wonderful time. Thanks. Bye.
Friends, if you liked today's show, please go to youtube.com/NRI Samay and click on the subscribe button. You will get notified every time we publish a new show. And you can also like us on our social media sites like Facebook, Twitter, and Google+.